Let's start in a very kind and soft way and talk about charitable relief.
Any money going to charity under your will or after you pass away will pass to them without you paying any tax on that sum.
And don't try doing this at home, because the legal drafting, the appropriate tax clauses are crucial to make it effective, aren't they?
How much would I need to redirect to benefit from the tax advantages, the lower tax rate?
Hello, today I'm going to be speaking to my colleague, Caroline Woodham, who is exactly the person I would go to if I wanted any tips on how to save inheritance tax. And let's face it, if you are facing an estate that's subject to inheritance tax, if you're due to inherit a little part of one, everybody is interested in this subject. So thanks for coming to chat with me today, Caroline.
You're welcome, good to see you.
Caroline, you're a fully accredited STEP lawyer, which is the Society of Trust and Estate Practitioners, which means you've got the highest accreditation that it's possible to have in this area. And I'm constantly fascinated about the solutions that you will come up with where clients are concerned or where you can see an opportunity for them. But let's start in a very kind and soft way and talk about charitable relief. Obviously, we have some clients who definitely wish to benefit charities for all the right reasons. But most of us would like to, were it not for the fact that we feel our family need or should or would like to inherit from us. But it is possible to benefit both at the same time, isn't it?
Exactly that. There are two advantages from an inheritance tax point of view when you benefit charities. The first is that any money going to charity under your will or after you pass away will pass to them without you paying any tax on that sum. And that's because of a tax exemption called charity exemption. And in addition to that, there is a tax rule that means if you give 10% of your estate to charity, then your overall tax liability is reduced and you pay tax at a rate of 36%, rather than the usual 40%.
Yeah.
So not only do you benefit from a tax saving on the money actually going to the charity, but the rest of your estate, the people that you love, also could be advantaged by a reduction in the tax they're paying too.
Yeah, so it's an all-win situation, isn't it?
Exactly that.
And those people who begrudge the fact that tax is being paid on monies acquired on which perhaps income tax has already been paid, which I know is a feeling that some people have, not everybody, but this is not tax evasion, of course. Don't ever think that. It's not even tax avoidance. It's actually just tax planning in a different way. And although we're not accountants, we're not financial advisors, there are people that do that for you. This is a legal drafting issue, isn't it?
Exactly that. And when a will is prepared by a legal professional experienced in these issues, they can draft within your will specific clauses that enable you to have these tax benefits, the lower tax rate of 36%, by ensuring your estate will give enough money to the charities that it needs to. The charities win, your other beneficiaries win. It's a good thing to do all round, really, because when charities have funds, they can help a lot of people in the community.
Yeah. But you don't need to be specific about the actual amount. Is it a percentage, isn't it?
You can do either. So if you're confident that you're going to be giving a significant sum to charity, far more than 10%, then we would maybe give a specific sum. But if you are doing it to get the tax advantages and make sure charities are benefited, you can have your will drafted in such a way that that 10% occurs irrespective of how much you end up being worth, because we can't always plan for everything that will happen in our futures.
No. Really interesting. And of course, there's a wonderful tool called a deed of variation.
There is.
Whereby this can actually be put into effect after someone's died if they didn't think of it when they made their will, or perhaps they made their will before the law changed to have this provision. So how do families go about that?
Well, when you have a loved one pass away and you're due to inherit money yourself, you're a beneficiary under that will or under the intestacy rules if your loved one didn't have a will in place. And you can redirect some or all of your inheritance to other people and to charities. And if you are minded to redirect some of your inheritance to charity, we would recommend you get legal advice to consider the issue of how much would I need to redirect to benefit from the tax advantages, the lower tax rate. For some, if you were thinking of making a small payment to charity, actually just making that payment and not worrying about the tax benefits makes more sense. But if you were to be gifting 8 or 9% to charity and the maths were undertaken for you, it could actually transpire that if you give 10% to charity, you receive more money because less tax is paid and the
Overall.
charities get more
Absolutely.
as well. So the document we do that redirection in is called a deed of variation. And it's important that that deed of variation is finalised within 2 years of a person's death. So it's always worth getting early advice if you're thinking about making changes, so that you've got time to think it through and work out what's best for you and your family.
Yes, and I've seen some of your wonderful financial illustrations of the before and the after before people make the final decision, which of course they need to think about very carefully. But the whole deed of variation concept, I know, is like a bit of magic, isn't it, thrown in that, as you mentioned, it's not only varying the way a will and an estate is distributed, or an intestacy, actually, isn't it?
It can be either.
It's not just to charity; it could be to different beneficiaries. So, if somebody is going to inherit from a parent, but in fact says, I could have done with that inheritance when I was 30, but now that I'm 65, I actually don't need it. But my kids could do with it. I'm going to give it to them to put a deposit down for their first property.
That, yes.
Can you explain to our listeners why it's so important that that is done by way of a deed of variation and they don't just give it out of the inheritance to them?
It is part of our law that gifts are possible. You can gift money that you have, money or assets, to whomever you choose, but there can be tax consequences to that. The basic gifting rule is if you make a gift of money and die within 7 years of making that gift, the money still forms part of your estate for your inheritance tax calculation, which means if you were working towards retirement age, doing a little bit of gift planning and wanted to give some money to a loved one, you would need to live for 7 years, otherwise you don't get any tax advantages from that gift. If you live for 7 years, then again, you're in a situation where everyone wins really, but for a lot of people, the future isn't guaranteed in that way. And one of the things that we sometimes think about, if you are in that situation where you're thinking about gifting, but you've also recently inherited money or expect to inherit money shortly, then you may want to have a deed of variation put in place so that rather than you inheriting the money, the people you would otherwise be gifting to inherit the money instead. The biggest advantage of that is you're not treated as if you made that gift for the purposes of the 7-year rule. Instead, it's treated as if the person who died made the gift directly to your chosen beneficiaries bypassing you.
So in the example I gave, grandma left it straight to grandchild as opposed to grandma leaving it to parent who gave it to grandchild.
That.
No 7-year rule risk.
Exactly that. And I think you're at risk sometimes if grandma's estate were subject to tax and you inherit, and then your estate is subject to tax. When the grandchildren eventually receive that money, they've paid tax twice.
Yeah.
And there are some rules that help with that situation, but it becomes far more complicated. Whereas a deed of variation could skip you entirely, allow the money to go from grandma to your child in a single transaction. Grandma's estate may still be taxed, but your estate won't be taxed on that money and you're not treated as making a gift for the 7-year rule purposes.
And my top tip to anyone who's thinking about that is, you heard what she said, within 2 years, absolutely, otherwise there's no point. and it takes quite a long time to get it exactly how you want it.
Yes.
So early on, and don't try doing this at home, because the legal drafting, the appropriate tax clauses are crucial to make it effective, aren't they?
You need to be aware of the details of the Inheritance Tax Act and
the Capital Gains
and
Tax.
the Capital Gains Tax Act, and they are complicated pieces of law that we've spent many, many years learning, studying,
and keeping up to date with.
Exactly that. So it is definitely one of those areas that I would strongly recommend having a professional involved to make sure that you've thought through all of the potential pitfalls, you're aware of any consequences, and the end product actually works for you.
Brilliant. Thanks, Caroline. You mentioned the 7-year rule many times, and lots of people quote that at me in all sorts of contexts. Some of them I gently say, actually, no, that doesn't apply.
Yes.
Can you just explain a little bit about the 7-year rule in a bit more detail, and where you can't gift things away and avoid the 7-year rule, and what the 7-year rule is, basically, because everyone loves that phrase, especially certain newspapers quote it all the time.
So in its very basic sense, the rule is that if you gift money, an asset, or a benefit to another person and you die within 7 years of making that gift, you still have the asset you gifted in your tax calculation when you die. If you live for more than 7 years, then you don't. So if I were to gift £100,000 and live for 8 years, I would get around that 7-year rule and I wouldn't pay any inheritance tax on that money I'd gifted. If, however, I died after 6 years, it would still be in my estate, and on my death, my money would add that onto it before the tax is calculated. You have to be careful when gifting, because there are tax rules that work separately to the 7-year rule and can mean you fall foul of still paying tax, even if you think you've lived beyond 7 years and you'll be fine. And the biggest one that we are concerned about is something called a gift with reservation of benefit.
Oh, I've heard about this. It's called a grob.
It is. It is indeed. And a gift with reservation of benefit, or a grob, is a rule that means if you gift but you retain any benefit from the making of that gift, your estate still holds the asset that you've gifted. The most common scenario that we think about is the gifting of a holiday home. You've had a holiday home on the coast somewhere nice that you've held for a few years, but it's worth a bit of money and it's going up, as properties sometimes do. And you want to pass that on to your family so that they get the benefit of that holiday home for years to come. But you also want to visit it a few times a year. If you were to gift that property to your children and continue to have your 2-3 times a year holidays at that property, you're still getting a benefit from the house that you gave away. And so you would potentially get caught by these gift with reservation of benefit rules. And that would mean that you don't own the house, you can't do whatever you want with it, but you still pay tax on it when you die. You have to be very careful, and that occurs in all sorts of scenarios, but that holiday home situation is a very easy one to visualise.
So is there a solution to that?
Potentially, you would be able to continue to holiday in that home as long as you paid the new owners, your children, whomever,
rent.
The going market rate that property would be rented for on the open market.
Yeah, and another problem that I know people have to be careful of is if they make gifts and then die within 7 years, like maybe £50,000 to somebody, and then they die within 7 years, and that £50,000 is brought back in and inheritance is tax payable. If the beneficiaries of the estate are different people, who pays that inheritance tax?
It depends on the value of the gift, but the starting point is that tax is paid from your estate assets on death first.
So if I was to give you £50,000 and then die a couple of years later,
your children might not be very pleased with that
so
decision.
I might need to have specified, actually, if I die within 7 years, you pay that tax,
exactly
please.
That, yes.
So that's why it's really important, isn't it, to get those documents drawn up and correct advice at the right time before you go away giving very large gifts with a view to saving your estate tax in due course.
Yes,
Yeah.
indeed. And it's one of those topics that does come up in our line of work fairly regularly. And the outcome can be different to the expected outcome.
Yeah.
We find that a lot of our clients will take advice when planning their wills, when planning their estate, their tax position after they've passed away, but they won't always think about coming to us when they're making the gifts at the point that they're making the gifts.
No.
And actually that's the point in time where the advice is most useful.
Definitely.
Because that's when decisions can be changed based on the advice. Once it's done, it's done.
Exactly, yes. And that very often when people are supporting their young people buying properties these days, because we've mentioned property quite a bit, but of course property has gone up in value so much that it affects lots of things.
Yes.
And gifting from the bank of mum and dad, as it's so often called, it should be done with advice in terms of inheritance tax, shouldn't it?
It should. It should be done looking at your financial position as a whole, looking at the tax position on your estate as a whole, and with you being fully informed of any consequences of making that gift.
Yeah.
It's not to say that the advice won't be, yes, make the gift, but being aware of
how to make it
and knowing what you don't know about gifting, having somebody who's got the experience and the qualifications to fill you in on some of the lesser known nuances.
Still on the subject of inheritance tax, but also still on the subject of property in a way, I'm old enough to remember when the inheritance tax limit wasn't £1 million.
Yes, as am I, Melinda, as am I.
It's not that long ago, is it? Let's be a bit kinder to ourselves. So £1 million, but of course the crucial element is it has to contain a property, or had to have contained a property at some point.
Yes. So the starting point is if you own a property that is or has been your residential home when you pass away, and that property or assets equivalent to the property are passing to your children, your grandchildren, what's known as lineal descendants in the formal terms. Then there are extra tax allowances that can be claimed by your executors. That tax allowance is called a residence nil rate band, and it could be really advantageous if it's claimable. But we find some of our clients have, for various reasons, sold their property before they've died. It may be because they're moving in with family. It may be because they are moving into a care home, but also more broad reasons. People make decisions about their property for all sorts of reasons. And the concern when this law came out is, in that situation, are these people losing out because they don't own a property when they die? And that's not the case. There's a piece of law called the Downsizing Provisions that mean as long as you have owned a property that has been your home after the date set in law, then you can have your executors claim the residence tax allowance using the downsizing provisions and still get the benefit as if you owned the property when you died.
Huge benefit, isn't it?
It certainly can be.
How much is it? £175,000 per person, the value of the property?
It is. It's £175,000 per person, capped at the value of your interest in the property. But we live in the southeast, in our area, property values very regularly far exceed that sum. So that being capped isn't often a problem for us. And that residence nil rate band, the residential tax allowance, is also transferable between spouses. So you get various tax reliefs when one spouse dies and the other inherits, and on the death of the second spouse or civil partner, they can claim both tax allowances if they tick the right boxes and the law applies in their circumstances. So
really important, though, isn't it, to know that this is only available, this extent of tax relief is only available on estates where the first to die of a spouse has received 100% of the estate, and then they leave it to what's called lineal descendants, which is your own children. Unfortunately, those people who are not married or do not have children of their own do not have such high tax reliefs. We're not here to debate the merits or fairness of that. We're just really here to discuss how it sits. And so
that definition is fortunately quite broad. So it would include stepchildren, for example. But But yes, it is limited to that definition of lineal descendants.
Yeah.
So if you are passing your whole estate to other family members, nieces, nephews, siblings, etc., they wouldn't get the same advantages.
No, and similarly, that if you've had a life partner and lived together, unfortunately, you don't get that spousal relief either, do you? So
That's
the
exactly
limit
right.
on taxes...
So it's £325,000 for your normal nil rate band for an individual.
Which is pretty low when you're talking about property these days, isn't it? Particularly, as you say, in London and the South East.
Yes.
So I know that you've done this and I've done that, which is literally sit down with clients who are making their wills as a couple but who've chosen not to marry or have a civil partnership and literally say, mate, go and get married.
Exactly,
it will save a lot of tax.
Exactly that. If I have partners who have been together for a lengthy period of time, or sometimes not, and they are intending on spending their lives together in the very long term, but they aren't married, they aren't in a civil partnership, then I will always compare what their tax position will be if they stay as they are versus if they get married or in a civil partnership. And I think some are quite shocked with the difference in the bottom line figures. For some of my clients, the difference is paying tax and not.
And for some people, it's being able to stay in the home that they've got and not. And on that note, before we start to wrap this up, as I'm being told to do over there, unmarried couples, second marriages.
Yes.
People are sometimes fearful of getting married as to what that could mean. But provided they get the correct advice, certainly in terms of a will, they can secure their assets, can't they, for their family members?
They can do, yes. I think it's important, and we often work with our colleagues in different departments, the family law team, the property team, to make sure we're looking at the situation slightly more holistically.
Yes.
But there are options, and it's always worth getting advice, finding out about those options and working out what suits you and your personal circumstances best.
Yeah, we need clients to tell us what they want, how they live, what their dream is of the rest of their life, and we can put it together. Well, you certainly can.
Exactly that. And however complicated our clients perceive their circumstances to be, it's always worth having the conversation as a starting point. And we quite revel the challenge of a more complicated financial or family circumstance, because it makes us put our years of learning and experience to the test and work out a solution that suits our clients best.
Oh, thank you, Caroline. As I said at the outset, you're who I'd come to for this type of advice, and I'm sure that a lot of people would be very reassured and excited by the prospect of that. So thanks again for your time today.
You're more than welcome.